welcome everyone to the next episode of the JA Malta podcast. We're related to entrepreneurship, and today it's also connected with intellectual property. How will this work, and how is it used by entrepreneurs? I'd like to first thank our partners, the Family Business Office, the Malta Business Registry and the Commerce Department. And in fact, today I have Godwin Warr from the Commerce Department who will be talking to us about intellectual property. But first of all, a quick introduction of yourself, Godwin.
I've been with the Commerce Department for the past 44 years. I've been involved in intellectual property for at least 30 years of that time. So I've been seeing Malta's development in the area for some time now.
Excellent. So we have a wealth of knowledge here. So let's dive into it. So what is actually intellectual property? How would you describe that?
Well, I would like to distinguish between intellectual property and intellectual property rights.
Okay.
Sometimes intellectual property, many times nowadays, it is used to refer to the rights as well. But I would like to distinguish it at the outset. When we talk about intellectual property, really is anything which is the fruit of the human mind. If you go into the World Intellectual Property Organization, you go how it was originally defined. That's what intellectual property is. So basically, anything which throughout the years has been created or invented by humans would fall under the category of intellectual property. The rights are the rights which are given by the government of each individual country to the creators and inventors and the producers and what have you, to protect and encourage the creation and innovation of those intellectual property.
Okay. So when we're talking about the different mechanisms or the different types of protection, we're talking about, the rights and protection of intellectual property. Can you guide us through a bit or what are the types and differences between, briefly, obviously, because I know they're complex topics, but patent, copyright, trademark,
exactly.
Guide us a bit through that minefield.
Exactly. You already mentioned a couple of the most important. So when we say industrial property, we normally refer to trademarks, patents, and designs or registered designs in some countries. When you add to that copyright and other rights, you refer to the whole thing as intellectual property rights.
Okay.
In fact, as I already mentioned, the United Nations have actually a specialized agency dedicated to intellectual property, which is called the WIPO, the World Intellectual Property Organization. Having said that, most member states of the United Nations nowadays have their own office, which somehow or another caters for intellectual property. So we could start off perhaps with the most common and perhaps the easiest when it comes to intellectual property. We can talk about trademarks, for example.
Okay.
Now, again, trademarks have been with us in some form or other for many, many years, hundreds of years even. But it's different between having a trademark and between having a trademark right. So in the old times, for example, the potterer would actually make vases of clay and other creations, and he would somehow scribble his name or an indication that it came from his own studio, so to speak. Now I'm talking Egyptian time here, at the time of the pharaohs and even before that. So that was like a form of a trademark, because the idea of a trademark in itself is to distinguish the product or service of one company, one business, from the product or services of other companies. That is one of the main functions.
Okay.
I mean, if you look at the way that farmers used to brand their cattle. So they used to brand their cattle, and that's where the brand comes in. Yeah, they used to actually brand their cattle because the cattle would roam from one field to another or one pasture to another, they would get mixed up. And that way the farmers would know whose cow belongs to whom. Eventually, obviously, there was a lot of development in that area. We don't need to really go into that. But each country developed its own system. In fact, nowadays, because of the World Trade Organization, which obviously is there to administer how trade is conducted on a world stage, it is obligatory for the members of the World Trade Organization to have some form of intellectual property system, which includes the protection
sort of register of rights.
I said before, you could just be a member of the former GATT, the General Agreement on Tariff and Trade. Well, with the Trade Organization, World Trade Organization, there's a specific agreement called the TRIPS Agreement, Trade-Related Aspects of Intellectual Property. It's long-winded, but basically it is there to ensure that all the member states have at least a minimum set of rights. And so we're talking about trademarks. Now, as far as trademark are concerned, now let's say take Malta as an EU member state. Now, you can apply to have your trademark protected locally, and once you do that, it is protected only locally. And you can do that in each member state
individually.
Even obviously in non-EU countries, you can go down that route. But you can choose, if you're interested, let's say, well, I'm interested in protecting my trademark in more than one country in the EU, and perhaps even outside the EU. So you have options. So if you want to protect your trademark in more than one country in the EU, normally, if you want to protect it in more than 4 countries, it would be better for you to go the EU trademark route. So
apart from the Malta trademark route, there's an EU trademark.
Exactly. So what was traditionally known as the community trademark, but nowadays it is known as the EU trademark. And basically you apply directly with the EU IP office in Alicante. Obviously everything is done online. And once the trademark is issued, by the trademark registration is issued, that would be valid in all member states. So you have a right in all member states.
Why would it pay me to register it in Malta only, not EU-wide immediately?
Well, it depends on your business prospects, really. As I said, I mean, obviously it is not very costly to register it in Malta. But once you start going from one country to another, your cost starts to mount. You would have to face the fees, individual fees of each country.
So the EU is more costly than Malta alone. So that's where you decide.
But it's not more costly than 3 or 4 applications, because you not only have to look at it from another perspective as well. You might have to appoint a trademark attorney
to search whether it already exists.
And there might be communications with the other member states' IP office, who might not be conversant in the English language. So, for example, if you're going to apply, if your interest is in Finland, Romania, Italy, and Malta,
in Finnish.
So you might have. I mean, Finland are obviously most offices are conversant, but there might be. So you might have to assign a trademark attorney. It's not really obligatory, but you might have to. So that way you'll be saving on the fees, but you'll be saving also on the fees of each individual country. Now, as it is, each individual country will have its own subjective manner of assessing your trademark application. Now, there is harmonization of trademark rights. There is an EU trademark directive, and all member states have implemented the directive into their own legislation. But they would have implemented it as they interpreted it. And so one member state might accept a trademark a member state might not do so, and yet another might oblige you to make conditions or change it.
Mhm.
When you go into the EU IPO, you're just facing the EU IPO. It is there. Once it's there, it is valid, and the member state cannot refuse an EU trademark once it has become valid.
Okay. And in Malta, this registration of trademarks is done through the Commerce Department.
Exactly. Obviously, you can come to our website. It's 24 hours. It's advanced. We have a very advanced system with the help of the EU IPO. Actually, we've had a remote system facility even before COVID. So we're very advanced in that stage. And it's very important. Why, you may ask? Because obviously it's first to file.
Exactly.
So the guy who files the trademark first
wins.
will have preference on the other guy.
Yes.
So that's why you have this system.
So, yeah.
And our system affords you mentioned the search. You can do your own search if you want to.
Mhm, mhm. And just so that we touch upon briefly on the different types. So a copyright is basically anything that I write or I design is automatically copyrighted. Is that correct?
It is correct, but it covers more than that. So copyright covers literary, musical, artistic works, audiovisual works, semiconductor topographies. So it is very wide, and believe it or not, computer programs.
So software is copyrighted?
Is copyrighted because it is considered that software falls under the definition of a literary work.
Yeah, it's used in programming language,
Exactly.
and I wrote
Exactly.
in a
now, obviously, there have been attempts to change that in the past, but it was not successful. So it's still there.
Okay.
But there is still the possibility to try to protect your software through a patent, and I will explain that a bit more later. But it would have to be in a very technical way, and you won't get a patent for the software as such. It has to be allocated with a specific invention.
Okay.
So when it comes to copyright, sorry to interrupt.
Sure.
It is the advantage of copyright protection is once your creation, you mentioned a literary work or an artistic work, you put it down physically. It's not just in your mind.
Yes.
You're describing it.
As soon as I wrote it, let's say.
Exactly.
On
Somehow
paper.
it must be, yes, and somehow. It is, you have automatic copyright protection in all the member states of the Berne Convention. And Berne Convention is a convention which falls under the World Intellectual Property Organization, which is a UN.
And I don't need to register anything.
You don't need to register.
Once it's written, it's mine.
Exactly. Obviously, when a copyright case crops up, the argument is who did what first.
Exactly.
So it's best, whatever you do, you somehow have proof
of the date.
Of the date when you do it, etc. I mean, traditionally, when it comes to, for example, a book, they might call it the poor man's copyright. You actually put it in an envelope, register it, and post it back to yourself, and never open it.
Mm-hmm.
Obviously, it will be up to the magistrate to see
decide what proof is right.
It is protected for a long time. It is protected for 75 years after the death of the author.
Okay.
Having said that, there is practically an alphabet of exceptions and limitations. But that is the importance of copyright. And another issue, which is very important when it comes to copyright, is that we can both have copyright for the same thing if we created it individually without copying it. Independently of each other.
Even at different times?
Even at different times. As long as I can prove
that I didn't see yours before.
Exactly. Now this is different when it comes to the registered intellectual property. Registered intellectual property is always first to file.
Mm-hmm.
Some countries it might, like the US, they still cooperate with the first to invent system, but that's a different system. The majority of countries is first to file, especially when it comes to patents. I'm not talking about trademarks. I would like to skip from trademarks and copyright, which you mentioned, to designs.
Okay.
Why am I doing that? Because a design can be a trademark in itself. That's one of the
like logos design you're talking about here.
Well, I'm going even further than that. For example, let's say a bottle. I mean, the Coca-Cola bottle.
Yeah, the famous Coca-Cola.
The famous Coca-Cola.
The shape of it.
The shape of it. That is recognized as a trademark.
Okay.
Before that was possible, it was only the logo of the Coca-Cola which was recognized as a trademark. But eventually, I remember a time when in Malta it was not recognized as a trademark because our laws were different. We had different trademark laws. But as part of the EU directives and as part of the modern way of thinking about trademarks, anything which can distinguish your product.
Yes.
And obviously
it's trademarkable.
So you can possibly. It doesn't mean that every design is trademarkable.
Okay.
But
it's something you should look into.
And then that gives you stronger,
of course,
protection their copyright in the sense that you can prevent others, even if they created it without seeing your own trademark. You know?
Okay.
I mentioned design. That obviously you can register that as a design.
Okay.
So it will be a registered design. You're registering the aesthetic aspects of a product.
Okay.
Nowadays, even more so, design is very much important. I mean, people are used, for example, to let's say, the mobile phone. I was going to say the landline telephone, but that is really on the way out. So I would expect in a retro fashion it would come on the way in sometime or another.
Yes.
So you see, there is when it comes to the mobile phone, you've got the trademark of the maker.
Mm-hmm.
The way that the mobile phone works in itself would be protected by a patent.
Yeah.
If there's software in it, it might be protected by copyright as well. But the aesthetic way the mobile phone looks, you can protect that under registered design.
Exactly.
So you will be jumping from one intellectual property
for the same product.
From the same product.
Yes. And what is patentable?
So yes, now we come to patent. Well, it's important when you want to patent a product. That product has to be newly invented. It must have an inventive step. And I will explain this separately. And it must be industrially applicable. So what is meant by new? What do we mean when we say new? Well, the concept of novelty differs slightly sometimes, but basically it must not have been published or brought to the attention of the public anywhere in the world before you applied for the patent.
Okay. So
even your own publication can work against you.
Exactly.
So it's not just another person who invented something similar or identical. Even you, if you publish it, let's say in an Asiatic country, and then try to patent it in Italy, and then the researchers there find that you had published it and it was there available to the public, that would fall foul of novelty.
In the context of new entrepreneurs, so if they pitched an idea in a competition or in front of judges or Shark Tank and then they apply for the patent afterwards, does that mean the fact that they pitched the idea?
It depends on what they said in the pitch.
If they didn't go into the detail of how it
works.
Okay.
I mean, if you say, listen, I've got this new idea how to go from Valletta to Suii using this new contraption which I invented.
But then I don't give you the details of it.
But once you start saying, well, this works, it has this, you will have to charge it. When you start breaking it down,
then
Well,
you're starting going into risky
yeah,
waters.
you'll be risking.
Okay, so it has to be new and
Inventive step. An inventive step in some countries called non-obviousness as well. Basically, if you, let's say you have a pair of glasses and you know that there's the strength of the lenses. So you cannot just say, well, yeah, okay, I created new pairs of glasses. Now, this is the normal lens is +2. Now I'm creating a new set of glasses. The normal lens is +5. Well, that's not an inventive step.
Okay.
But if your glasses is like Visus, for example, or when it is dark, it lightens up when it is bright.
Something new.
So that there is an inventive step.
Okay.
So that's the point. Industry applicable. It must be doable.
Yeah.
You cannot just, just
An idea.
do a comic strip of it and expect to be given a patent.
Yes.
The examiners, or once you go into court, the attorneys who will be sort of challenging it, would challenge it on those rights.
Yeah.
Now, just a small point when it comes to patenting, and this applies for designs as well. You're protected in that country where you applied for.
Okay.
If you want to protect it in other countries, you have to use similar system to what I mentioned about trademarks.
Yes.
So when it comes to a design, you have the possibility of applying for a new design registration. Right now, a new regulation has been approved. There's a new directive, but the manner is the same. You go to Alicante, you look at the website and you follow the website. It's very detailed, it's very helpful. Okay. You want to apply nationally? Use our own website.
Go to Commerce Department.
When it comes to patents, you can either come to us, or else go to European Patent Office, or else go to the WIPO and get an even wider patent.
Costs vary accordingly.
Costs vary, but again, it would be cheaper than going individually to each member state.
Of course. And nowadays with AI, so if I'm creating something, but I also use the AI to help me generate something, be it a design, be it a book, be it a publication, whatever. How does that work now with protection? Sort of what rights do I have on protecting it if I actually use the AI to generate it?
Well, it's a very pointed question, very, very valid question. And most of what I will be saying is a personal opinion, really. It's not official, it's just personal. Just an indication of what's going on in this way. Now, if you look at IP rights, the reason IP rights were created were to promote innovation and creativity. So you protect the inventor and the creator because of the money, of the time, he invested in it. But also there's a social dimension. Because once you're encouraging him, he will be obviously creating more, or be interested in creating more. But there's always a human element. It doesn't mean that he cannot use tools to create.
Okay.
An artist would use the brush. Nowadays, they obviously, my daughter is a graphic designer. Most of the designs that she does it on her own tablet.
Yes.
We've got large paintings at home, which she did, but a lot of it nowadays is done. The design is done on computers, on her tablet. So there's nothing wrong with using tools, because you are using the tools to create your product. It's slightly different. I guess it's not slightly different. It's very different when it comes to a situation where you actually ask the
tool to create
the AI, listen, could you please create me a scene where the sun is going down, where there's a little bit of rain, probably put it a bit of shading of red in the background, and perhaps a shark fin going from one side to another than the sea. And the AI, because of the way it is structured, it does it for you. Now, you cannot really claim that you did that. You had the idea, but you cannot claim that.
Okay.
So you would probably face a problem if you were to seek protection
On
for
that painting.
when it comes to copywriting it. You know, if you have somebody does it and then you have a problem, can you really sue somebody for copying an artistic work which was created by the AI? Now that is one element. Is the AI itself infringing other people's intellectual property?
Because it's using a library of designs beforehand.
So again, there are exemptions and exemptions, and there's the digital rights, copyright in digital age directive in the EU, which is transposed in Maltese law as well. There are exceptions on how to do it, etc. But it's not that easy. This is an area which is coming to the fore.
And in fact, is the law keeping up with technology, you feel, or we're reacting to it?
The law has to react to it in this case. It's across the world that it's going to be. Because you have to be very careful that you have to create a balance. I do not think we should hold creativity and innovators from using AI to the fullest possible. But then the rights given shouldn't be used to thwart other innovators and creators from using their own their own way, their own traditional way. There could be other reasons why one has to be careful when it comes to AI. For example, I heard Antonio Campinos, who's the president of the European Patent Office. We held the European Inventors Award last year in Malta. Right now, when an inventor applies for an invention to have it protected with the EPO, with any office which have a substantive search, they would have their own examiners, professional scientific examiners. They use their own system, and they would search in a plethora of databases all over the world to assess the novelty criteria. That is done by them, and according to the hits or no hits, they would be ready to accept, to give you a patent or not. But what if we let AI do that? So we're having the inventors creating their inventions, not using AI, but getting the AI to create the invention, and having the examiner
using AI.
Letting the AI examine the invention. So basically we're getting software created products
being analyzed by software.
By software created. So there are other. It's not that there's the ethical issue. Obviously, there are the boundaries. The AI, for example, when it comes to trademarks, you could use AI. We already use some form of AI when it comes to searching when somebody applies for a trademark. But ultimately, there is so much case law when it comes to looking about whether a trademark is actually infringing, whether
too similar or...
So there has to be, the final say has to be of the human when it comes to intellectual property.
Agreed.
We might perhaps go towards creating some sort of a hybrid system where, depending on the amount of AI involvement, you might get protection or not. For example, we talk about crafts. So I'm also the registrar of crafts in Malta. So if we have somebody who applies to be a registered artisan, and we encourage that, by the way, we have over 900 registered artisans in Malta, and it's growing, thanks to our partners, the Malta Crafts Foundation, who was always encouraging new artists to come to us. And what do? Well, basically, we ask the artisan for an interview, and we either go on site or we make an online call, and he has to show us that he is actually creating
the piece himself.
We use the definition which is held by UNESCO. So there has to be a substantive amount of handmade production involved.
Yeah.
So we have no problem with you using tools, no problem with using AI.
But
there has to be a limit.
levels.
So that is the issue. That is the balance which we need to keep.
Okay.
We should promote AI. AI isn't the future. I already say we've already been using AI for some time, so we're living with it. But we should not be fearful of it.
No. If I could just one final question as well. When it comes to entrepreneurs, starting off their new business, their new ideas, or moving on to a new idea, when should they start handling this protection, seeing whether they are eligible in terms of timing? When should that happen?
Well, I would think, first of all, they will need to have their own, their own business plan. But before launching, before going public, they would need to start thinking and actually taking action to protect their IP rights.
Before going public.
Because, as I said, it's no use opening your own shop, your own business, using a trademark, promoting yourself, spending loads of money in marketing,
realizing it's used already,
and then somebody else is using it, and
yeah.
And when it comes to patents, obviously, it's even more so.
Yeah.
You shouldn't launch your product if you invented it unless you patent it. I have to point out there are sister organizations who help as well. So you can go to Business Fairs who guide you. There's Scienza Malta who would guide you as well.
Okay.
So
Depending
obviously you can always come to us. But when you open a business, normally you'll be going from one thing to another. So basically, if you go to Business Fairs, they should be able to listen. Have you thought about it?
And you also have some fund or some awards related to this,
Thank
right?
you for that. Well, yes, when it comes to protecting industrial products, industrial property, so patents, trademarks, and designs, you can get up to 75% refund.
Okay.
To do that, please go to the EU IPO site, because there's a way how to do it. It's important to go to the site before you actually submit an application.
Okay.
Because if you submit an application, it might not be possible for you to get the refund. So you go to the EU IPO site, look at SME funds, and you might eventually get a refund of your trademark application, patent application, design application. And we have the Malta Intellectual Property Awards, which is launched every year right now. It has been running for some time now. So I encourage you to always be on the lookout. There's always a nice kitty for it. We have about 60,000 euros, which we distributed among creators, inventors, and also emerging inventors, emerging innovators. So 30 plus, but even youngsters as well will be eligible for this.
Excellent. Thank you, Godwin, for your time, for your knowledge. We tried to touch upon certain things, but I suggest obviously to get in touch with the Commerce Department with any doubts. I'm sure they will be able to help you. So thank you again, Godwin.
Thank you for the opportunity.
Keep an eye out on the funding as well and follow the instructions. I thank the listeners for joining us and thank the partners, the Commerce Department, the MBR, and the Family Business Office. So continue following our socials for more episodes coming soon. Thank you.